Testing 1 2, testing 1 2. Testing 1 2, testing 1 2. Alrighty. What's up, everybody? Your host, Supreme Decisions, and I'm here to talk about when defenses are made available because of the public safety exception, and what is it that we're going to do, right? Because I actually had someone bring this up, and I want to say this is the second time I've actually heard of this in the last maybe month and a half. It's not something that I felt was common until I started going back and I started looking at a few other ones. They didn't word it as public safety exception, but they did use a form of the public safety exception in their verbiage. And so that actually have me looking differently now at a few of the, what do you call, the police reports as they come in, learning the stock language, because they're using a different issue, because I actually labeled it as officer safety, which similar defenses, not the same. Now, the great question of the public safety exception must often come up within the Miranda context. This is why I associated it with the officer safety exception. Now, the public safety exception comes from New York v. Quarles, and it's a 1984 case. But officers and prosecutors sometimes try to stretch it into justifying both an arrest and subsequent charges. When this happens, a defense attorney has multiple avenues to push back, and also the defendant as a pro se litigant, because the exception is very narrow. This is why, again, I associated it with something else versus what it actually is. Now, here are, again, a couple of free gems for you. Now, we're going to challenge the scope of the exception. Now, the public safety exception applies only to questions asked because Miranda warnings when there is an imminent threat to public safety. Now, in this context, and let's say there's an arrest being made and there's a gun involved. This is one reason why they throw in, do you have a weapon in the vehicle? Because they can then use the public safety exception for doing other stuff, such as putting you in handcuffs while they're talking or investigating. These things don't fly unless there is a means for it, because what they can use is there could possibly be harm to bystanders, even if there are none within 100 yards. And even in the context of this, I call this the minority report defense, because could, possibly, might is not a defense. Just like I don't know is not an actual defense for police officers whenever they ask you or to do something or say something crazy to you. So just keep that in mind. If the questioning goes beyond neutralizing an imminent danger, the defense can argue that the statements or evidence must be suppressed. This is why you have the Wade hearings. This is why you make sure you're challenging everything. Well, not the Wade hearings, but MAP hearings. And this is why you challenge everything, because even what they're saying can and will be used against them if you have someone that is guiding you in a way that you can use it, or you have someone vigorously defending you. If you don't have a vigorous defense, these things will never be brought up. And then once you don't bring them up, I've said this 100 times, you can't then bring it up later on appeal. It has to be done initially. And courts strictly limit the exception. If police use it to ask about general criminal activity or past crimes, this is outside the scope of the exception. Because again, even if they ask there's a gun in the car, they can't then go into some other tangent about what could possibly might happen or what has previously happened unless you all open the door with a full-blown conversation and responding other than what you are required to. Because again, in my due to the advice of counsel, hold on, let me make sure I'm looking at the camera. Due to the advice of counsel and the Fifth Amendment protections, I choose not to answer this or any further questions. Now, once you say that statement, it now falls under Miranda. If they continue questioning, everything subsequently is now ordered for suppression because an illegal act cannot be preceded by an illegal one. Once you invoke, they then must follow law. And if they choose not to do so, they are in violation, and everything about it is fruit of the poisonous tree. This is why I constantly teach this, because to stay safe, you have to abide by the process, line by line, precept upon precept. Now, the second part will be attack the necessity of the exception. Argue that there are no objectionably reasonable threat to the public safety. Now, a lot of times we want to do officer safety. And again, this is why I correlate that with that, because they'll ask you to get out the car. They'll use Pennsylvania v. Mims, and the contextualizing of it will be wrapped in the public safety exception. Now, I actually said this when I was talking about Pennsylvania v. Mims. Challenge what was the ongoing threat that required you to be taken out the vehicle and then being placed into handcuffs, because being subjected to felonious conditions absent a crime is illegal. I don't know how else to say that, because again, I say it and say it and say it and show you, and all you have to do is follow. Here it is. Even if you call me once you do this and they arrest you, it makes my job in guiding you easier. The whole point is to make this as easy as possible, because they are not trained on how to properly invoke or execute unlawful and lawful issues. They don't know law. I don't know how else to say that either, because I've shown you. Jordan B., City of New London, they are not hiring intelligent people. I can say it until I'm blue in the face. You have to understand what it is that is done out of necessity. Now, if the suspect was handcuffed and the area is secure, there is no immediate risk to justifying bypassing Miranda. I'll say that one more time. If someone is handcuffed and the area is secure, basically you have multiple officers there, there is no reason for them to bypass Miranda, because at that point you are arrested. Rather than, oh, no, you're not under arrest. You're just being detained in handcuffs away from your vehicle without consent. They now must justify that. These are the things that I constantly talk about, because when you're not doing that, you're allowing poor behavior to continue. Now, courts look for whether a reasonable officer will believe that there was danger. Now, when they're using the word a reasonable officer, the reason why they used officer in this context is because police officers are being taught. I'm going to say they're being taught that everybody is a danger and going to hurt them. That's why I asked the question, are we training cowards or killers? Because that's what we're training, one of the two. Because we're turning these cowards into killers. So since we're using just the officer's perspective, the officer then gets to determine whether the justification is available. Because if you are afraid of everything, everything is then reasonable. I'm going to say that one more time. If you are afraid of everything, everything is then reasonable. That's why they use that word. Verbiage. Understand the context of words. Just because you don't like them, just because you want to change the meaning of them, does not mean the verbiage or the meaning of that word has changed, nor the application. Understand what it is that I'm saying to you. Now, the defense can argue the officer's claim is speculative and manufactured. This is just a direction of guidance. Now, it doesn't mean you're going to win. Always understand that. You're not setting up to win every battle. You're being set up and coached and guided to win the war. Always understand that. I'm not training you to or educating you on how to win every battle. Just like chess, you're going to lose some pieces. And it's okay. It's all right. We're keeping the king alive. We're protecting the king, which is you. So going through that is understanding the context of what is going on and how it's being set up. Now, the argument is just that. It's your defense on why they can't do what they did. And guess what? They don't know they can't do it. Because I'm going to go back to Blake Simmons. If you're in Frisco or somewhere here in Texas and you're pulled over by Blake Simmons, challenge it. Because one of the things I love about Officer Johnson that was with Blake Simmons, he's on the record. And if you need that record, contact me. Because Officer Johnson said he does this, referring to Blake Simmons, he does this all the time, which means he's violating people's rights all the time. And you too can sue him in his individual capacity. And then the new department he's at, because they hired knowing he does this all the time, is also liable. His supervisor, knowing he does this all the time, is liable. These are the things that you go ahead and take along with you, because I keep dropping these gems for you. Because even one, I watched a video last night that was one of the most beautiful things in the world. Sergeant comes to the scene, and she's explaining to, I guess the guy's friend that was with him. She says, yeah, he's getting arrested. The friend goes, what charges? She said, I don't know. He said, well, aren't you going to find out? She said, yeah, he'll tell me eventually. Said, but if it's an unconstitutional arrest, she stops him and goes, I trust my guys. He then goes, well, you do realize that can lead to a lawsuit. Now, the reason why she was so nonchalant about it is because most people never follow through. I'll get my lawyer. 90% of people don't have a lawyer. I'll sue you. 95% of people don't sue. So she was playing the odds. But he goes, you know you are also responsible for his actions because you are okaying his behavior. Then the video goes off. But you could visibly see that she at least had heard it before because her body language changed. She didn't know exactly what it was, but she at least had heard it before because her body language changed. Lawsuit, no, didn't faze her. When he told her she is also liable for her officer's actions because she okayed it, her body language told you everything you need to know, because this is what you also do. You hold the supervisors. You hold them, whether they come to the scene or not. You hold them accountable. You go after the prosecutor for malicious prosecution when they know these officers are doing these things, such as Blake Simmons. Wherever he's at, the prosecutor is also now personally liable because whether he's on a list or not, he's a Brady cop. And I'm going to ask you something else. I want you to understand something. You see a lot of people, they don't say the names of these police officers. You have to wonder why there's a reason why I am so free-flowing with saying their names. You have to ask yourself that question. And just like I just said with Officer Johnson, I've got the video. I've got evidence. I'm not just going to say somebody's name and don't have evidence. I'm not just going to blurt out something and it's not available. Just understand that. So there's a reason that whenever I say this, or I say these are Brady cops, or I say these other things, I've got something to back that up. Jesus. Let me trace this correctly. There we go. I hadn't even noticed that. How do I not notice that? Anyway. Now, challenge probable cause for arrest. This has to be my favorite one because I've gone over countless numbers of time where I spoke about the Supreme Court case that states, one, because we already know they're not people with high IQs, but then I go over Malloy v. Hogan. Police officers don't know what probable cause is, which is why they go get a warrant when they don't have consent. I'm going to repeat it. Malloy v. Hogan. Police officers don't know what probable cause is because they aren't intelligent enough to know what their job is. They're not trained on what actual probable cause is, which is why they need consent or a warrant. Now, challenging probable cause for arrest, the exception only justifies questioning without Miranda, not an arrest without probable cause. Challenge everything. And what's up, Parham? Great to see you, brother. And if the arrest itself lack probable cause, any evidence flowing from it, statements, searches, confessions, is subject to suppression under the Fourth Amendment. And that's Wanson v. U.S., and it's a 1963 case. You know what? Clearly established. There are several rulings on each circuit court that goes along with that statement. Always understand that. So when we're putting things together, understand you're coming to me because we're trying to win. That's the only reason you call me, because you want to win your case. That's why you set up the consultation, because winning is the thing that you want to do. And you want to challenge. Get a little sippy sip. And this is water. All right. Now, suppression of derivative evidence. Now, you haven't heard me speak about it, but you've heard me speak about it. I haven't referred to it as derivative evidence. Most time it's fruit of the poisonous tree whenever I have context of it. If a police elicits statements under the guise of public safety, but without proper grounds, anything discovered as a result, weapons, contraband, even confessions from other people, can be excluded. Even if they ask, hey, you have any weapons in the car? They can be excluded. Always understand that. Once you're in handcuffs, why are you talking? You don't interrupt the enemies while they're doing what they're doing. I'm going to say it that way. I'm going to keep it PG. They're not doing themselves any favors. The defense argued the exception cannot create evidence the police could not have found legally otherwise. And this is one of those, again, why they call it derivative evidence, because it's one of those where I've actually seen them use it to the context of they found evidence that they quote unquote would not have found, but they based it on, well, we would have heard it from this other person, when in fact the other person had never given them any context in which would have guided them to the evidence that they found. So understand, but again, it's been allowed several times. Even if they're going through these things and not following through properly. Now, the due process and coercion argument. Now, I've said this 1,000 times. The interrogations themselves are designed to coerce. The stop is designed to coerce you. The police officer uniform is designed to coerce you. It's designed to intimidate and strike fear. It's designed that way. Why? This is why the programming in which most of us were brought up to believe police are good people, because it's designed that way. Now, if questioning under the public safety exception was actual interrogation pressure disguised as safety concerns, a defendant can argue the statements were involuntary and violate the 4th and 14th Amendments under the due process protections, because you have the right to remain silent. Most of us don't exert the ability to have that, because you shouldn't be talking unless, if you have a means to protect yourself, 99.9% of the times the protection comes with quiet, because they don't know how to respond to someone that's not interacting with them. Because even I talked briefly about an interrogation technique, which is probably the most masterful, because we are all designed to correct people, and we're also programmed to defend ourselves when someone says something crazy. And I did not realize that is being used by FBI agents, that's being used by CIA agents, and it's being trained not only at Quantico, but it's being trained here in Texas, because again, Texas has the longest training here in the United States. If I'm wrong, let me know, because to be a police officer here in Texas, it takes, I want to say 11 and a half months. So it takes a full year. And part of their training is the conversational aspects of it. Now, one of the training facilities is freaking wonderful. It's beautiful, and it's literally right down the street from my house. It's one of the most beautiful places that you'll ever see. It looks like a resort. But again, that's a police training facility that's here in Texas. And most people are trained here. Most police officers are trained here. But understanding the context of it, they are being trained on how to solicit answers from you without asking a question. And it's because they are attacking human nature. And I wish I could give you an example of it, because I literally watched the video the other day and I was like, this is crazy. And then I talked to one of my homeboys who's a cop here, and he was explaining, he's like, they teach us that. And I was just dumbfounded, because with me, I'm such an asshole, I can respond with protective measures. Now, most people aren't geared that way. So even if you're looking to justify or argue with them about something they said about you, oh, well, you look like a guy that did this. My response is, love to see that description. Because I know none of them are going to say 6'4", 300-pound dude running. Because I ain't ran for anything. I don't even run to the refrigerator with my fat self. But understanding, they will say things because they want you to, well, I was just right down there. And that statement puts you in the vicinity. That puts you somewhere that they can now lie and use against you somewhere else. Oh, well, yeah, he admitted to being it. No, I didn't. I love to see that description. Or, well, what size shoe you wear? Oh, those are mighty big shoes. Absolutely. I'm a big dude. Most people say, "Oh, well, yeah, I wear a size 14." Now, if they got a size 14 somewhere in that area where there was a break-in, at, you're now the burglary suspect. And then you don't have a real alibi. Why? Because most times you're on your phone and sitting in your house, or you're asleep. But you wear a size 14, and they were Nikes, and you have a pair of size 14 Nikes at your house. So now you're the burglary suspect. Now you're the person that they're convicting because you don't have an alibi. These are tactics that they use by not asking questions to get you to incriminate yourself through human nature. And even these statements, that even if the statements aren't suppressed, a defense could argue to a jury that the prosecutor's alignment of public safety shows weakness in their case and they need shortcuts to build. But probable cause, because now there's a separate set of aspects that jump in that you would have to defend. But again, it's somebody that's going to put together the context of what that would be and how to build it for a zealous defense, which you are required to have. Now, cross-examinations can highlight inconsistencies in the officer's claim that public safety require immediate questioning. Now, they're going to use, again, all kind of BS. Oh, well, we had several break-ins in the area and we had cars being... Not justification. But if it's unchallenged, it then goes in as accepted. Anything that's not challenged is accepted. And that's why I always say you're either part of the problem or you're part of the solution. So if you're not challenging, you're part of the problem. If you're just paying a fee whenever somebody stops you, you're part of the problem. If you're just accepting what these fools are telling you, when you know they're not intelligent, when you know they don't know law, when you know they're just doing this for revenue, you're part of the problem. That is why you challenge everything. Now, the case law that you can rely on for leverage is New York v. Coors 1984 case, the original case creating the exception, narrow and fact specific. Dickerson v. U.S., it's a 2000 case, reaffirmed Miranda as a constitutional rule. Say that one more time. Dickerson v. U.S., 2000 case, reaffirmed Miranda as a constitutional rule. You have the right to remain silent. It reinforces the Fifth Amendment. And exceptions must remain narrow. Missouri versus Siebert, 2004. Police cannot deliberately use two-step interrogations, which is question first, Miranda later. Because again, you're in handcuffs and they're questioning you and they haven't read you your Miranda rights. That is a baseline for you being able to challenge any statements made, because they can't go in reverse order. They've already subjected you to felonious conditions, which you can challenge. The bottom line is the defense strategy is to show that the public safety exception was stretched beyond its intended purpose. It does not erase constitutional protection. It only excuses Miranda in very limited emergency-like situations, because you're going to challenge the emergency. What was the emergency which you could not read Miranda, and why you kept them or you subject to felonious conditions? Anything beyond that can be challenged as a Fifth Amendment and 14th or Fourth Amendment violation and goes under the 14th Amendment in application to the state for the due process violation. So thank you guys. Let's keep going. Let's keep growing. Don't forget super chats. Don't forget to donate to the channel. And don't forget to share. And if you need a consultation, don't forget to hit the link or email me at greatestnow@yahoo.com. And I will see you guys probably in the next hour, because I got another one for you.